Okay.
Okay, hi everyone. Today we would like to present about insurance law, which is called is DPN20023. So our topic is negligence. So before we start, let us introduce ourselves. My name is Li Xuan and my number matrix is 0
Hi everyone, my name is Eng Xuan Lee and my matrix number is 01821F1024.
Hi everyone, my name is Sharmita Anaparupa Jagdisan and my matrix number is 08GIN21F1029.
So our lecture evaluation is one Anita Binti Slim. So we consider four content, which is what is negligence, situation of negligence, element of negligence, and conclusion. So what is negligence? Negligence in law, the fail to meet a standard of behavior established to protect society against unreasonable risk. Negligence is the cornerstone of tort liability and a key factor in most personal injury and property damage trial. Negligence is a legal theory that must be proved before you can hold a person or a company legal responsibility for the harm you serve. Uh, Negligence claims must prove 14 in court. First one is duty, second breach, third is causation, and fourth one is damages or harm. Generally speaking, when someone acts in a careless way and cause an injury to another person under legal principle of negligence of the careless person will legal liable for any resulting harm. So these are the situation of negligence. First one is a property owner who failed to replace rotten step on a wooden porch that collapsed and injury with sitting guests. Second one is a driver who runs a stop sign causing a injury crash. The next slide I will pass to Shenli.
Thank you, XY. The first element is duty of care. It makes a person responsible for taking reasonable care to avoid harm being caused to another. For instance, Ali wanted to ask a question of the produce manager at supermarket, and he straight away went in even though the door was marked employees only. After that, he accidentally leaned against the stack of crates. The crates collapsed and injured himself. Ali would not have a good liability claim because the store had no duty to protect customers who ignored signs and wandered around where they are not supposed to be. Now the slide will continue by Shamita.
Thank you, Shanli. So, what is breach of duty? Breach of duty occurs when a person's conduct fails to meet an applicable standard of care, and it also refers to carelessness on part of defendant which cause injury or damage to the plaintiff. In consequence, if the defendant's conduct fails to meet the required standard of care, they are said to have breached their duty. Next. Now, let's look into the example situation for the breach of duty. A customer drops a container of milk at the grocery store. An employee cleans up the spill and moves the area. However, the employee does not put up a wet floor sign over the wet spot. Another customer walks by, slips and falls, and breaks an arm. A jury might find that the grocery store breached their duty to maintain safe premises for their customers by not using a wet floor sign to alert customers to a hazard. A reasonable grocery store employee will typically place a wet floor sign or a spill to ensure the safety of customers. Next. Now I'm going to explain about the injury or damage. The defendant's negligence must cause the claimant's loss and the loss must have been a foreseeable consequence of the breach of duty. The aim is to compensate the claimant by putting them in the position that they would have been had the contract been performed. Next. The example situation for injury or damage is the manager of sports equipment store displays heavy medicine balls on the flimsy top shelf. The shelf collapses and the balls start tumbling down rapidly, striking a customer on the head and causing him suffer a concussion. The customer has to miss several weeks of work and receive a pricey hospital bill. So the monetary compensation will compensate the customer for his injury, loss, wages, and medical expenses. Next, I will pass the slide to Xuan Li. Thank you.
Okay, thank you, Shamita. Lastly, remoteness of damage relates to the requirement that the damage must be of foreseeable type. In negligence claims, once the claimant has established that the defendant owes them the duty of care and is in breach of that duty which caused damage, they must be also demonstrate that the damage was not too remote. For example, Ali is driving on the road. He hits a girl on the footpath. The girl tumbles on the bicycle, breaks her finger. In the above situation, the girl being hit is direct damage, and it is direct damage caused by the act of Abu. And it also been noted by that culpability to negligence is made on the assumption that the person is aware of the fact that rash driving can lead to fatalities, though the expected and actually result might not be the same. The slide will pass to XY.
In conclusion, negligence of as a thought has evolved as a substantially important thought. In order to prove that an act was negligent, it is necessary to prove all the essential. So this is our presentation. Thank you.